right, good morning. This is the Colorado Energy and Carbon Management Commission. It is Wednesday, March 20th, 9 a.m. We will start with a roll call.
Thank you, Mr. Chair. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner McGowan,
Here.
Commissioner Mesner, Commissioner Oath, Commissioner Ray, Commissioner Robbins.
Here.
Mr. Chair, you have 4 out of 7 commissioners present today.
Excellent. Good morning, folks. Would note the others are excused for their not being able to be here today, but we do have quorum. We have one matter on our agenda today, if I'm looking at the agenda correctly, but we will start with commissioner comments. Does any commissioner have comments for the good of the cause? Seeing no comments, we do not have a consent agenda, so we move to our first and only docket. That's 2303-00083, a matter involving an oil and gas development plan. And this is oral argument on Summit Oil and Gas motion to reconsider order number 535-1459, denying the proposed Castor 7-599 OGDP. If we could bring Mr. Willis to the panel. Good morning, Mr. Willis. You are muted.
Very good. Good morning, Chair. I just have about a 14-minute statement I'd like to kick off with. If I could just launch into that. I have a couple other individuals, Sam Bradley and Benjamin Pitsley, who are also available should there be any questions. So I'll just run off with your permission.
Yeah, before you run off, I know that as part of your motion for reconsideration, you are asking the commission to grant an ability to provide new evidence and testimony in the record. I, as chair, am not inclined to go that route. I believe you had an ample opportunity to present your evidence at the time of the hearing and over the course of preparing the application. I also would note that I, as chair, along with my fellow commissioners, provided you with ample opportunity to continue the matter, to further develop your case, and you chose not to. So you are absolutely allowed to present us with oral argument on your motion for reconsideration, but I would encourage you to not go into new evidence. If you want to make an argument about why you should be able to present new evidence, that's fine. But I'd rather you not present new evidence in your argument itself. Fair?
That's fine. And yes, and I think my statement addresses it in that context, Chairman.
Great. Then you have 15 minutes.
Thank you. Good morning, members of the commission. My name is Rob Willis, Senior Counsel at Post Nodell and Peterson Law Firm, and I have the pleasure of representing Summit Oil and Gas, LLC, as to its motion to reconsider today. Summit is a registered operator with the commission. The business is comprised of experienced and talented oil and gas professionals who excel in both planning and developing projects. They work within the structure of ECMC, other state agencies, and local government rules, and when posed with challenges under those rules, they diligently work to find collaborative solutions. You will recall that Summit last appeared before you on January 17. Certain members of Summit's team presented information supporting their Castor 7-599 OGDP application for lands located in northeastern Weld County near the town of New Raymer. The OGDP consists of 1,920 acres, or 3 sections of farmland, with a stand-up orientation to accommodate the drilling of 16 1.5 mile horizontal wells in north-south and south-north orientations from the proposed Castor 9 oil and gas location located in the middle of the proposed OGDP. The Castor 9 location is situated in the middle of agricultural farmland and is in CPW mapped high priority habitat to protect both mule deer and pronghorn antelope. Summit also responded to written and oral questions from the commission during that hearing. On review of the hearing from that day, members of the commission deliberated long and hard commissioners wrangled with two primary concerns for the development, as those concerns related to the adverse impact in HPH for primarily pronghorn antelope. These concerns were Summit's desire for up to 16 yearly rig mobilizations to develop the lands, and two, the need to use trucks to haul both produced water and oil from location. Following deliberation, the commission voted 3-2 to deny the OGDP application, which was memorialized in ECMC order number 535-1459. Prior to voting, the commission may have been inclined to continue the matter for hearing to allow Summit to present additional evidence related to its concerns. On that day, Summit was not inclined to accept continuation of the deliberations. However, in the interim, Summit has continued to work to resolve those issues, giving rise to the defeat of its OGDP application. More on steps taken by Summit in a few minutes. By way of background, as Summit took steps to meet energy demands of your constituents, it obtained leasehold interests for oil and gas underlying its OGDP, including interests from the state of Colorado. Summit has negotiated a surface use agreement for the proposed Castor 9 location in the northwest southeast of Section 9, Township 7 North, Range 59 West. On March 23, 2023, as it was working towards completing permits required under Rule 303A, Summit submitted its OGDP application, which was subsequently amended on August 8, 2023. With its OGDP application, Summit submitted a companion drilling and spacing unit application to cover downhole development of hydrocarbon-bearing pools underlying the OGDP, along with technical testimony in support of establishing the drilling unit. Acting in conjunction with submitting these applications to the Commission, Summit worked diligently on completing its Form 2A Oil and Gas Location Assessment, Form 2B Cumulative Impact Data Identification, and Form 2C OGDP Certification. On April 6, 2023, Weld County, after providing legal notice to all affected parties, including CDPHE and CPW, approved Summit's WOGLA application. It should be noted that CPW did not attend the WOGLA hearing, but it did file a report noting the proposed Castor 9 location, though not CPW's recommended location, was protective of wildlife resources. On November 28, 2023, CDPHE, along with Summit personnel and ECMC staff, conducted a CDPHE site consultation, wherein Summit committed to certain BMPs as conditions of approval to regulatory permits involving the number of tanks proposed for the Castor 9 location. On December 20th, 23, as a follow-up to an initial pre-application consultation, which took place on November 29 of 2022, Summit, CPW, ECMC, and Weld County conducted a consultation to discuss the proposed Castor 9 location, alternative locations, and site-specific mitigation measures to protect wintering big game, including pronghorn antelope. As a result of this consultation, Summit agreed to provide CPW with compensatory mitigation and adhere to BMPs to protect winter concentration area for both pronghorn antelope and mule deer in high priority habitat. The compensatory mitigation in BMPs, which include restrictive timing stipulations to avoid rig occupations in HPH winter season, are memorialized in the CPW Wildlife Consultation Summary Letter. On January 9, 2024, ECM issued its director's recommendation, which, in summary, recommended approval of the Castor 7-599 OGDP, reciting that CPW and Summit chose to mitigate direct and indirect HPH impacts through compensatory mitigation, and that CPW had no objections or outstanding issues with the Commission approving the OGDP application, which included approval of the Castor 9 location. Certain information presented in the director's recommendation infers that Summit will continually drill the 16 wells during one rig mobilization. However, Summit has always maintained its intent to utilize several rig mobilizations, which can be confirmed by looking at Form 2B. There were no public comments or petitions filed in opposition to the OGDP application. At the January 17 hearing, Summit provided engineering testimony supporting its plan configuration for developing its OGDP and the Castor 9 location by describing processes for optimal downhole development of the reserves underlying the lands. Summit also indicated that up to 16 rig mobilizations may be necessary to drill all contemplated horizontal wells needed to efficiently and economically drain oil and gas resources underlying the OGDP. Summit also testified that, in its opinion, getting pipelines to or near the Castor 9 location to transfer product were possible at a future date, but that there were no existing pipelines which could be utilized to take product from location, and without pipeline takeaway, fluids would need to be trucked from location. Now for an update on efforts by Summit to take steps to minimize impacts associated with activities from its planned OGDP, which will, in turn, mitigate impacts. It should be noted that Summit brought this matter to your attention by utilizing Rule 121 of the Colorado Rules of Civil Procedure. However, as typical for all commission orders, including Order Number 535-1459, it contains the order provision, open quote, "The commission expressly reserves its right to alter, amend, and repeal any and all of its orders," close quote. Summit would like you to consider updated information by offers of proof today. As panelists, I've included Sam Bradley and Benjamin Pitsley today. These gentlemen can provide sworn testimony consistent with offers I'd like to make now. First, the total number of storage tanks to handle both produced water and oil are to be reduced from up to 48 tanks downward to no more than 12 tanks. Second, reduce the number of rig mobilizations for drilling and completion activities downward from 16 to no more than 8. In addition, Summit would delay any planned drilling activity to Q2 of 2025 after the April 30th CPW BMPs to minimize impact to HPH big game winter season utilization. Why the delay? The answer is to provide additional and necessary time for the laying of a pipeline by a midstream company who has just recently obtained regulatory approval for a produced water line to take away produced water from the Castor 9 location. This pipeline should be laid by fall of 2024. Summit will continue to pursue plans with a midstream company for an additional pipeline to transport oil from the location. Lastly, Summit would like to provide the Commission with transparent truck traffic projections based on data known to Summit, consistent with Summit's revised rig mobilizations and takeaway of both produced water and oil from the Castor 9 location. Without produced water pipeline takeaway, it is estimated that an average of 6.1 truckloads per day would be required over the life of the location for an estimated 2.4 average truckloads per day from year 9 onward, year 9 being when all 16 wells are drilled and producing. Summit anticipates a significant reduction in truck traffic each year as it drills new wells to minimize impacts during pronghorn winter season. With produced water pipeline takeaway, Summit estimates a reduction of 39% on average daily truck loads over the life of the pad, from 6.1 to 3.7 loads for both development and production phases, and from 2.4 to 1.1 loads per day from year 9 onward. Importantly, during pronghorn winter season, between 1 to 4 loads will be required to haul oil from location, with an average of 1.5 loads per day over the life of the pad. And it must be noted in passing that while each proposed OGDP must stand on its own merits, Summit took notice of this Commission's consideration of a similarly situated OGDP at its January 31st hearing, located in the same general area of operations proposed by Summit for its OGDP, with similar concerns regarding alternate location analysis, development of HPH lands, giving rise to CPW concerns on fragmentation of big game winter concentration area, and the need to utilize trucks to get product to market. This application was approved on a 3-2 vote. Senate Bill 18181 represented a significant shift in Colorado's regulatory landscape as it emphasized the import of prioritizing public health, safety, welfare, and environment with wildlife resources. Avoidance of impacts for this project is best represented by considering Summit's site selection through alternate location assessment criteria by selecting a site that avoids sensitive areas and is distant from existing oil and gas activities while committing to perform any necessary Plains sharp-tail grouse survey coupled with the avoidance of construction activities annually from January through April when big game may utilize the lands in winter. Summit is also committed to not set fencing around the Castor 9 location unless absolutely necessary. Further, advancements in horizontal drilling technology allow Summit to avoid using 2 surface disturbances to efficiently and economically drain the resource underlying the OGDP. Summit's OGDP planning has embraced minimizing the impact on public health, safety, welfare, the environment, and wildlife resources by utilizing 1 surface disturbance to develop the entire 3-section, 1,920-acre OGDP. Summit has envisioned using electricity over internal combustion gas-fired engines, and its recent success in negotiating with the midstream company for a produced water pipeline to minimize its daily impacts during production. Summit steps towards mitigation are best demonstrated by its monitoring plans and compensation measures. Summit continuously monitors its sites remotely, coupled with daily visits, and utilizes emission sensors with automated remote controls and shutdown capabilities. As to compensation measures, where CPW has demonstrated Summit's impact is unavoidable, it has committed to direct and indirect compensatory mitigation. In light of this information provided today, Summit requests that you reconsider order number 535-1459 and approve its Castor 7-59-9 OGDP application and associated application to establish a 1,920-acre drilling and spacing unit to cover the OGDP. Thank you for your time. Summit is present should you have any questions. That concludes my statement and my argument today, Chairman.
All right, thank you, Mr. Willis. I've got some thoughts, but before we do that, I'll just see if any commissioner has a question for Mr. Willis. Commissioner Cross.
Thank you, Chair. And thank you, Mr. Willis, for the presentation. I just want to start. What is the manifest error that we face here?
The manifest error would be the fact that in considering, I suppose it would require you to at least consider the offers of proof that have been made today. In so much that
but in our decision, was there something that you presented that we wholly ignored that would have changed our ruling?
No, other than the fact that I think it's appropriate for you to take into consideration your ruling in a similarly situated OGDP, which was approved a couple of weeks from that, which was very similar, if not even more similar than other OGDPs that are brought before you for consideration, which was approved.
And I think we can debate the similarities and differences with the Red Hawk application that you're talking about. But I'm just curious, was there any factual evidence that we ignored in our decision that would have changed our ruling?
I can't say that. I can't say that. And I think that's why in my argument I pointed to the fact that your rules in itself indicate that the commission retains jurisdiction over its orders and can amend and modify their orders as necessary. And so I think this is an argument of judicial economy more than anything. in that there are other ways that we could bring the application back to you. We could process it through again if we needed to. That would take additional time and also have an impact on your processes. And this matter has been before you on January 17 when you denied the application. And what Summit is attempting to do today is to let you know that it continues to work on this and would like an opportunity to at least open your consideration of the OGDP backup instead of having to renotice it if they choose to refile.
And I'll get to the legal aspect of it in a minute, but as Chair Robbins said in the introduction, during the hearing, we also provided your client an opportunity to continue the hearing to work on this evidence that you're now saying is available too, did we not?
Yes, you did, and I recall that quite well on my review of the videotape that day, and Summit chose not to take that invitation and continue it to another day. And I think that what was indicated by Summit on that day was, boy, we need to get this product to market, and the only vehicle that we can use right now, which is identifiable, is through truck hauling because there wasn't a pipeline. But there's been a big change since that, obviously now, and I've made record of that, I suppose, through my offer of proof, and that's that a water pipeline has been agreed to with a midstream company, and it's going to be laid by fall of 2024 to the location, which will alleviate much of the trucking concern.
Okay, and going back to the manifest error issue, was there any legal argument in our decision that you're asserting the commission ruled incorrectly upon?
Well, I certainly would have hoped that on Summit's behalf that a different resolution would have been made that day, or a different result would have been made by the commission that day. I didn't participate in the deliberation. The commission obviously has the sole province in entering its orders, and they chose to deny the application that day based on the evidence that was presented. And I can't point to anything which would give rise to manifest injustice. But again, the rule also indicates that there could be a different result if the matter were to be reconsidered, and it wouldn't require you to at least open up your minds and the record to allow you to deliberate on this offer of proof that was made today by me, which can be supported by two witnesses that testified on January 17.
Okay, that's the only questions I have for now.
All right, any other questions from commissioners? Commissioner Cross?
Sorry, I do have one more question. I just wanted to comment on one question in your brief, and this is not necessarily just for this issue, but also for potential other issues moving forward. One of the points you made in your brief is that the WOGLA permit is a vested property right. And I agree with that, but I just want to make sure that you're not trying to argue that because you have a vested property right with the WOGLA permit, that the ECMC automatically has to approve the application as well. Okay.
No.
That's the only questions I have. Thank you.
All right. We'll move to deliberations, and I'll start deliberating a bit here for the good of the cause. So you filed a motion to reconsider. The motion to reconsider can only be granted when the commission has patently misunderstood a party, has made a decision outside the adversarial issues presented, has made a mistake, not of reasoning, but of apprehension, and that there has been a significant change or development of the law or facts since submission of the issues to the commission. You're also arguing that a subsequent matter was similar to this matter, and somehow or another that should have bearing here. I do not find that to be accurate. There are differences between the Roth OGDP and the Castor OGDP. For instance, the Roth location is not exactly in the center of the section, while the Castor was. There was an existing two-track road adjacent to the Roth location. Red Hawk predicted a smaller number of truck trips, as opposed to the trips predicted by Summit. The surface owner requested use of that location. Red Hawk proposed a single occupation, while Summit proposed multiple occupations up to 16. I do understand that with the offer of proof today, there potentially could be some changes to some of that. However, I'm not inclined to relitigate a matter on a motion to reconsider in this vein. We have a thorough set of procedural rules to ensure that when something comes to us, it's thoroughly vetted by our commission staff, by CPW, by stakeholders, etc. There needs to be some certainty with regard to the decisions we make, and allowing additional information and evidence at this late date doesn't correlate with the vigorous review and approval process that we've set up. I would remind the applicant that they always have an opportunity to resubmit with information they think carries the burden of proof, which is on the applicant, and resubmit in a fashion that allows all of the potential parties involved that have been carefully orchestrated to ensure that our review is appropriate at the time it gets to us. But coming back in after the fact and potentially providing additional new evidence at this time that doesn't get vetted by staff, that doesn't get vetted by Weld County, that doesn't get vetted by CPW, it just upends the entire process. The process is built so that we can provide fairness and certainty to all parties, including the applicant. And so I, as one commissioner, based upon all the foregoing, am not in favor of granting a motion for reconsideration, granting a motion to allow new evidence into the record at this late date. I would encourage the applicant that if it feels comfortable that with the development of a produced water pipeline and other things, that it can carry the burden of proof to refile its application and move through the process as we intended. Those are my deliberative thoughts. Commissioner Cross?
Thank you, Mr. Chair. In short, I'll say I agree. From a legal perspective, I think it's very clear. Our choices are, was there manifest legal error? And I would note that the brief started off saying there was manifest error, but ultimately, as we just saw in the questions, it's not that there were facts that were presented that we did not consider. There was no legal question that we improperly ruled upon. And so ultimately, I think we have to deny this motion. I'm in agreement. I think that, you know, if there is additional evidence and the applicant thinks that they can now meet this minimization by having less truck trips through produced water takeaway, I fully encourage refiling. I think that was one of the big things that was ultimately at issue at the time. And as we've talked about several times, there was an opportunity to continue. And I understand the desire to get the product to market, but at the same time, the desire to get the product to market does not mean we get to, ease our regulations and ease our rules. And ultimately, to me, I think the applicant should be in a pretty good situation now. If they already had the materials to make sure that the application reached completeness, it should have a fairly quick review. It should be able to go through faster. But trying to say that judicial economy is served by just reopening something that we previously denied, I think is not helpful, because that's going to set a bad precedent. And then people will continue to change things and say, well, what about now? Well, what about now? Well, what about now? So for me, it's beyond the idea that things have changed to open up a previous decision. It needs to be refiled.
Thank you, Commissioner Cross. Other commissioners, Commissioner Ackerman?
Thank you, Mr. Chair. The preponderance of what I had to say has already been covered by you and by Commissioner Cross, so I won't repeat, but I did want to just make one additional point, that it was raised that the vote was 3-2 to deny. And to the casual listener, that might seem that it was a close decision. I wanted to point out that the two dissenting commissioners specifically noted that they only voted no on the motion because they preferred a continuation for Summit to resolve issues that were raised during the hearing, which opportunity has been noticed, as has been noted several times during this hearing. Summit repeatedly denied during that hearing, stating that any continuance would simply present the same information already presented during that hearing. So the two that voted not to deny weren't necessarily voting in favor of the application at that condition at that time.
Yeah, thank you, Commissioner Ackerman. That's wisely noted. I appreciate that. Further discussion or deliberation? Seeing none, do we have a motion? Commissioner Cross?
I move to deny the motion for reconsideration.
Second.
Motion and a second. Further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? The motion for reconsideration is denied. Again, Mr. Willis, we appreciate the applicant's attention to this process. I think you've heard from pretty much all of us that there are procedural opportunities that exist for the applicant. I do agree with Commissioner Cross that there will be efficiencies to refiling because of the work that's been done. And we cast no aspersion onto the applicant or to the folks that are behind the applicant. We appreciate the hard work that they have done. We know them, and we hope to see them again at a future date.
Thank you.
Thank you. Thank you, Mr. Pitzler. Commissioners, I believe that is the sole matter on our agenda. Did anybody have anything further? Seeing none, I would move to adjourn. Do I have a second?
Second.
Motion and a second. Quick hearing this morning. Thanks, everybody. All those in favor of the motion to adjourn signify by saying aye.
Aye.
Any opposed? See ya next time.